I've been the fly on the wall for more than 2 decades of sectional title disputes. I've got the data, the rules, and the real-world solutions. You're watching at Scheme Savvy, sectional title simplified. Living in a South African townhouse means sharing more than just walls. It means sharing a legal boundary of peace and quiet. That boundary is governed by Prescribed Conduct Rule 7, the ultimate authority on nuisances, obstructions, and guest liability. Let's break down exactly what the national law says and how it applies to your everyday lifestyle. Subsection 1 deals with the ultimate point of estate drama, noise. The black letter law states that an owner or occupier of a section must not create noise likely to interfere with another person's peaceful enjoyment of their home or their peaceful enjoyment of the common property. When disputes arise, CSOS adjudicators consistently apply what is called the objective reasonableness test. They look at whether a sound exceeds the limits of normal community toleration. The established legal benchmark is clear. Any noise that wakes a neighbor up or keeps them awake at an inappropriate time is unreasonable. Official CSOS case summaries have had to rule on extreme examples, ranging from screaming domestic shouting matches on balconies late at night, to what circulars humorously referred to as strenuous and allegedly far too noisy adult activities. This same subsection also governs the modern cannabis balcony battleground. Ever since private cannabis use was decriminalized, smoke drifting from courtyards or balconies into open windows has become a massive driver of CSOS applications. Adjudicators have drawn a firm line here. You have a right to consume privately inside your section, but your rights end where your neighbor's nose begins. If drifting smoke continuously and unreasonably infringes on a neighbor's well-being, it constitutes an actionable nuisance, and offenders are routinely ordered to restrict smoking to sealed indoor areas. Subsection 1 even applies to DIY hobbyists and home businesses. While doing occasional home maintenance is perfectly acceptable, extended industrial-grade noise crosses the legal line. Adjudicators frequently crack down on residents running circular saws for hours to make furniture or revving motorbikes in driveways. In these cases, CSOS routinely issues orders restricting power tools to highly limited hours, completely banning them on Sundays and public holidays. Next, subsection 2 tackles common property gridlocks, specifically obstructions. The rule dictates that an owner or occupier must not obstruct the lawful use of the common property by any other person. In plain English, driveways, walkways, passages, and communal spaces belong to everyone and cannot be blocked. But here is the real kicker, especially for landlords, Airbnb hosts, and frequent entertainers. Subsection 3 introduces strict visitor liability. The law explicitly mandates that an owner or occupier must take reasonable steps to ensure that their visitors do not behave in a way likely to interfere with the peaceful enjoyment of another section or the common property. This has become a critical shield against high turnover short-term rental chaos. When holiday guests throw rowdy parties or trash the communal pool area, bodies corporate take the owners straight to CSOS. Because of subsection 3, adjudicators hold the unit owner directly liable for failing to manage them, ordering them to implement strict guest screening, post physical copies of the rules inside the unit, and face heavy consequences if their visitors continue to cause a nuisance. Finally, subsection 4 makes this rule completely inescapable. It states that an occupier is obliged to comply with these conduct rules, notwithstanding any provision to the contrary contained in any lease or any other grant of rights of occupancy. This means even if a private landlord writes a custom clause into a rental agreement trying to bypass the rules, the national law overrules it instantly. The conduct rules stand supreme. Understanding prescribed conduct. Rule 7 isn't about looking for fights. It's about understanding the basic legal baseline that keeps estate communities functional. Subscribe to Scheme Savvy, and let's keep estate living simple.